Hello, everyone, and welcome. As we continue our deep dive into intellectual property, we're now tackling one of the big ones, patents. We're going to explore the legal framework that takes an invention from just a thought, a simple idea, and turns it into a really powerful, legally protected asset. I think we've all been there. You have that aha moment, that flash of brilliance. But right after that excitement, a crucial question pops up, especially from a legal standpoint. What's next? What's to stop someone else from just taking that idea and running with it? Well, that's the exact problem the entire patent system was designed to solve. So, let's get a clear definition on the table. A patent is an exclusive right, and it's granted by the government. But here's a really key detail. It's not a right to do something, it's what we call a negative right. It gives the patent holder the power to exclude others from making, using, or selling their invention. Think of it as a temporary government-backed monopoly, really a reward for your ingenuity. And the origin of the word patent actually tells us everything we need to know about the philosophy behind it. It comes from the Latin patere, which means to lay open. This really gets to the heart of the deal, the quid pro quo of patent law. The deal is this. In exchange for those powerful exclusive rights, you, the inventor, have to publicly disclose all the details of your invention. You have to lay it open, so to speak, for everyone to see, which enriches our collective pool of knowledge. Now, as you can imagine, a right this powerful isn't just handed out for any old idea. An invention has to go through a series of really tough legal tests. I like to think of it as a patentability gauntlet. Your idea has to run through it and come out the other side to prove it's worthy of protection. Okay, so let's break down these three essential tests. First, your invention has to be novel. That means it has to be new, something that wasn't already out there in the public domain before you filed your application. Second, it has to be non-obvious, or what we call having an inventive step. This is a bit trickier. The question is, would someone who's an expert in that field find your invention to be an obvious next step? It can't just be a minor tweak. And finally, it has to be useful, meaning it has some kind of industrial application. It has to do something practical. And on the flip side, it's just as important to know what you can't patent. The Indian Patents Act of 1970 is very clear about this. You can't, for example, patent a scientific discovery, like E=mc². That belongs to everyone. The same goes for mathematical formulas or things like traditional knowledge. The goal here is to reward the practical application of an idea, not the discovery of some fundamental truth of the universe, and of course, to protect our national and cultural interests. All right, so let's say your invention makes it through the gauntlet. It's novel, non-obvious, and useful. What happens next? How do you actually formalize these rights? We're now moving from what an invention needs to be to what you need to do to turn it into a legal asset. The process really kicks off when the inventor files a detailed application with the Indian Patent Office. This document has to describe the invention inside and out. Then, a patent examiner gets to work. They do a deep dive, checking to make sure your invention really does meet those three critical tests we just talked about: novelty, inventive step, and industrial application. But what if your invention has potential all over the world? See, an Indian patent only protects you in India. Patents are territorial. That's where something like the Patent Cooperation Treaty, or PCT, becomes incredibly important. It basically streamlines the process, letting you file one single international application to start the patent-seeking process in a whole bunch of countries at once. It's a fantastic tool for global protection. So how long does this protection last? This is a huge deal. The standard term for a patent in India and under international agreements is 20 years from the day you file the application. That number wasn't just picked out of a hat. It's meant to be a careful balance, long enough to give inventors a real incentive to innovate, but not so long that it's forever. After those 20 years, the invention enters the public domain and it's free for anyone to use. So once that patent is granted, you, the patentee, are officially handed a bundle of very powerful rights. Let's take a look at what this power actually looks like in the real world, in the marketplace. These are really the big four. First, you have the exclusive right to exploit it, to make it, use it, sell it yourself. You also have the right to license it, meaning you can let others use your technology for a fee or royalties. That can be a massive source of revenue. You can even sell the patent itself, which is called the right to assign it. And maybe most importantly, you have the right to sue anyone who infringes on your patent. But remember that deal we talked about earlier, the social contract? Well, it's a two-way street. These rights are incredibly powerful, but they are not absolute. The law puts certain limits and obligations on the patent holder to make sure the public interest is still being served. A perfect example of this is something called compulsory licensing. Let's say there's a life-saving drug that's patented, but it's not available to enough people in India, or it's just way too expensive. In a situation like that, the government can step in and grant a license to another company to produce that drug, even without the patent holder's permission. It's a powerful tool to ensure patents don't end up harming public welfare. And there are other checks and balances too. The government can use a patented invention for its own public purposes. If an invention is vital for national defense, it can be placed under secrecy directions. And if a patent holder just sits on their invention and doesn't make it available to the public, their patent can actually be revoked. The message from the law is pretty clear. A patent is a privilege, and it comes with some serious responsibilities. So what happens when someone just ignores all these rights? When they use a patented invention without permission? Well, that brings us to the legal concept of patent infringement. Simply put, infringement is when someone, without getting permission, makes, uses, sells, or even just imports something that is protected by a patent. It's a direct violation of that exclusive right we've been talking about, the right that was granted by the government. And when that happens, the patent holder isn't helpless. They can file an infringement suit in court. And what are they looking for? Usually two main things: an injunction, which is a court order that forces the infringer to stop what they're doing, and damages, to get compensated for the money they lost because of the infringement. Which brings us right back to the central question, the big idea at the heart of all patent law. This entire system, from top to bottom, is a delicate balancing act. On one hand, we want to reward inventors with a temporary monopoly to encourage them to create. But on the other hand, we need to make sure that those new inventions ultimately benefit everyone. Finding that perfect balance? Well, that's the ongoing challenge for everyone involved in the world of patent law.